Good morning, ladies and gentlemen. The Law Day ceremony is about to be started. Please check your cell phones so we don't have any interruptions during this spirited debate. Thank you.
Good morning, ladies and gentlemen. Good morning, Chief Judge DePentima. Thank you for opening the court for us this morning. Judges Grondell, Judge Beach, and Dean Brad Saxton from Connecticut Law School. On behalf of the Connecticut Bar Association, we appreciate everyone's participation in today's Law Day event. I'm Ralph Monaco. I'm the immediate past president of the Connecticut Bar Association, and we are delighted to co-sponsor this event with the Connecticut Judicial Branch and with Civics First. I'd like to thank in particular Melissa Farley and Jill Begman for your efforts in helping us to coordinate this. We very much appreciate that. And I'd also like to thank Beth DeLuco and our friends at Civics First for your invaluable assistance with this. I know how busy you've been with the debate competition. And we would like to thank the Valley Regional High School, Mrs. Nids, and the two students who were among the stars of this year's debate competition, Phoebe Petrovic and Katie Mulligan. We hope that this experience is as educational for you as we hope that it is for us. And we thank you for your involvement. Your success on your debate team is a testament to your commitment to understanding important issues in our state and our society and speaking up about these things. Now, you may have, when you saw the format, been somewhat intimidated by the two distinguished debaters that we have placed on the other side of the table. I wish to thank them. They can blame me solely for asking them to do this, but I thank them both for representing the bar today. They've both held positions as officers with our Bar Association, and we look forward to their comments during the debate. As all judges and lawyers know, the three rules for any type of oral argument are preparation, preparation, and preparation. And we know that you are very well prepared today. And in view of that, you need not be concerned with the cumulative 75 years of experience as attorneys that Mark and Ann have, nor do you need to be concerned with the fact that Ann is a former associate judge of this honorable court, nor be concerned that she had a long distinguished career prosecuting major felony cases, including the Charles Buck Thurman case. You should not be concerned that Attorney Dubois has been board-certified trial lawyer for 20 years, or that he's a nationally recognized authority in attorney ethics, having served as the Chief Disciplinary Counsel for 7 years. No need to be concerned about any of these things because you are prepared, you are prepared, and you are prepared. And that is what matters in any oral argument. Today we come here to debate an important topic facing our community, our state, and our nation, whether the rule of law should allow state government to trump the authority of local government to run their school system. Today we come here to recognize Law Day 2012 and to reflect on the American Bar Association's theme, no courts, no justice, no freedom. Without our courts, disputes such as the one that we are about to hear have no promise of peaceful resolution under principles of law. For over a half a century, our nation has paused on May 1st of each year to recognize Law Day and to recognize the importance and privilege of the rule of law. President Dwight D. Eisenhower began this tradition on May 1st, 1958, in part as a response to the communist celebration of May Day. In declaring May 1st to be Law Day, President Eisenhower stated, in a very real sense, the world no longer has a choice between force and law. If civilization is to survive, it must choose the rule of law. And in 1961, the United States Congress passed a joint resolution, Public Law 87-20, declaring May 1st as the official day for celebrating Law Day. So on this day here in Connecticut, we look forward to debating in a discussion pitting the rights of a local community to self-govern versus the authority of the sovereign to govern for the general welfare of the inhabitants of its state. And we have asked Governor Malloy to recognize this as Law Day, and at this time I'd like to briefly read a statement by His Excellency Daniel P. Malloy, Governor. Whereas since 1958, Law Day has been an annual celebration of our country's heritage of liberty, justice, and equality under law. Whereas Law Day provides an opportunity to highlight civic education and to acknowledge our historic commitment to the rule of law. And whereas our nation recognizes that a fair and impartial judiciary is the foundation upon which our freedoms against unjust oppression and tyranny are built and protected. Whereas our democracy, to remain viable, depends upon our citizens' continuing understanding and support of a court system that is free from political pressure and influence. And whereas the theme of Law Day 2012, No Courts, No Justice, No Freedom, underscores the importance of the courts and their role in ensuring access to justice for all Americans, now, therefore, I, Daniel P. Malloy, Governor of the State of Connecticut, do hereby officially proclaim May 1, 2012 as Law Day in the State of Connecticut. I urge all citizens, schools, businesses, legal professionals, and the media of Connecticut to use this occasion to preserve and strengthen the rule of law. Signed by Daniel P. Malloy. And with that backdrop, it is my great pleasure and high privilege to introduce the Chief Judge of this Honorable Appellate Court, Judge Andrea Davis DiPentino.
Good morning. I want to thank you all for being here this morning and welcome you all to the Appellate Court. I'm happy to see that we have a representative from the Supreme Court here in Attorney Jonathan Weiner, and I appreciate his presence here as well. We like to let the Supreme Court know how nice our court is. I also want to say on behalf of the Appellate Court, and in particular on behalf of Judges Grundell and Beach, and I see also Judge Levine is here, that we are particularly happy to welcome such esteemed guests this morning as Ralph Monaco, past president of the Connecticut Bar Association, Anne C. Dranginis, formerly of this court, Mark Dubois, erstwhile Chief Disciplinary Counsel for the State of Connecticut, Brad Saxton, Dean of the Quinnipiac University School of Law, Beth DeLuco, the Executive Director of Civics First, and last but not least, these remarkable students from Valley Regional High School. This is our first Law Day ceremony here at the Appellate Court at 75 Elm Street. And I just want you to know that Attorney Monaco's remarks probably intimidated these folks here more than they intimidated me. It's true. I'm just briefly going to say a few things about why Law Day is important. It's been a holiday to me as a lawyer ever since I became a lawyer. It's an important day because it provides those of us in the legal profession the opportunity to reflect on the impact of our work on and off the bench, in and outside of the courtroom, and the fundamental role our legal system plays in our democracy. For example, in considering this year's Law Day theme, No Courts, No Justice, No Freedom, I was reminded of the work of the judges, the lawyers, and the judicial branch employees over the past 5 years to improve our delivery of justice to the citizens of Connecticut. In 2007, Chief Justice Rogers created the Public Service and Trust Commission, which was charged with creating a 5-year strategic plan for the judicial branch. One of the 5 goals speaks directly to the Law Day theme of today. The judicial branch will provide equal access to all of its facilities, processes, and information through the identification and elimination of barriers. Over the past 5 years, remarkable progress has been made to eliminate those identified barriers to access, from improving signs and directions within and outside of each of the courts throughout the state, to enhancing the judicial branch website by adding more case-related and court information on our ADA procedures for requesting accommodations, to eliminating barriers to those with limited English proficiency through bilingual forms, telephonic language lines, and interpreter and translator services at no cost to the parties. In addition, the branch and the lawyers and the law schools have worked with the bar to address the growing number of litigants without representation through various pro bono programs, and we now have court service centers and greeters in most of our courts. We must continue this work towards the goal of equal access to our courts so that we can preserve those foundations of our democracy, justice, and freedom. Again, welcome to the Appellate Court, and our thanks to the Connecticut Bar Association and Civics First for joining with the branch to sponsor this first-time event. I'm now going to introduce the Executive Director, Attorney Beth DeLuca.
Good morning and welcome everyone. Thank you for coming out for this. Civics First is a private nonprofit with over 30 years of experience advancing law and democracy education in Connecticut schools through programs such as our high school debate competition. This year, over 40 high school teams around the state competed in March, and our state champion from Academy of Little Farm was unable to participate today. So our state finalists from Valley Regional High School were willing to step in for this first ever student attorney debate. Thank you to Barbara Nitsporsky for her willingness to always step in when we need people. Attorney Monaco was kind enough to make the students a little more nervous than they already were by giving the biographies of our esteemed members of the bar. So now it's my turn. Phoebe Petrovic is our top speaker for the state this year. From Valley Regional High School, and only a sophomore, so look out when she's a senior. Phoebe has been involved in debate and mock trial for her 2 years at Valley Regional High School as well as during her 2 years of middle school. Phoebe won the American Legion Oratory Competition at Valley and went on to compete in Westbrook at the district level. She also was a member of the Model United Nations team for the past 2 years that competes at Clark University. Phoebe competed at Yale this year in the Osterweiss Parliamentary Debate Tournament. Phoebe is also a writer for her school newspaper, a member of the Interact Club, volunteers for her town library, and runs both track and cross country. How's that? Katie Mulligan, Valley Regional High School sophomore also, is a dedicated high school sophomore from Essex, Connecticut. Her love for debate and mock trial began 4 years ago when Katie was introduced to the teams by her instructor, Ms. Nitz. Ever since, she has made sure there was time for debate and mock trial in her busy schedule. She's involved in numerous extracurricular activities, including musicals, field hockey, and the Interact Club, where she is a group leader in facilitating community volunteer projects. She is also, if anybody's ever heard of, the co-host of an Emmy Award-winning TV show called Aqua Kids, where she travels around the country to educate youth on protecting marine and aquatic environments. Katie is looking forward to a career in law. Hopefully now we've evened up the slate a little bit here. So good luck to all. I guess I'm not done. I have to explain how the format works. So this is cross-examination debate. The topic today that they just got a week ago, so both teams have only had a week to prepare this, is resolved that the state of Connecticut should no longer be allowed to take over municipal school systems. The way this works is we have a first affirmative and a second affirmative, a first negative and a second negative. And they also have turns questioning each other. Each person has their specific time slot, and each person has their specific other person that they need to question. Then we have rebuttals. If you look on your schedule for today, you'll see the order of the speakers and their time limits. There will be a timer that will let them know when their time is up, and they have also 5 minutes of preparation time that they can take at any time during the debate in increments of 60 seconds each, and the timekeeper keeps track of that as well. Thank you.
Do you have timekeeper?
Where?
Yeah, stuff.
We have a timekeeper?
Do you have extra paper?
Yes.
Oh, no. Thank you. I'm just going to write time cards. Okay.
I'll be the timekeeper, Your Honor, because so that you can watch your students.
You want to do it?
I think you'd much rather watch your students. I'm happy to do it.
Oh, okay.
You're welcome. Great. Are you ready to proceed?
Yes.
First affirmative constructive speech. Your Honor, are the judges ready?
Yes, thank you. I'd just like to introduce the timekeeper. The timekeeper is Attorney Alice Bruno, who is Executive Director of the Connecticut Bar Association.
Thank you, Your Honor.
If the timekeeper can sit down here, then you can.
Oh, that makes sense. You mean not stand behind her?
Yeah.
Thank you. You can tell the first time. If you bear with me, I'm just going to get my handy iPhone so I have an actual countdown.
Can everyone hear me like this? Is that loud enough? Is that better?
It was on.
Oh,
You're going to have to keep your voice up.
all right.
Just 1 minute.
Do you mind if I give you these? You hold this one up when there's 1 minute left and stop.
You've got it. Thank you.
Thank
Do
you.
you want anything, 1 minute left?
Yeah, that's
Thank you. I apologize, Your Honor. I wasn't prepared for this role. And I turned my phone off because I wanted to behave, so it just needs a second to turn on. Start.
Good afternoon, Your Honors. My name is Phoebe Petrick, and I will be speaking on behalf of the First Affirmative. Stanford professor of education Michael Kirst once said that, quote, often, educational policy debates focus more on what should be done, rather than on which institution should be authorized to make and implement policy. Today, we argue that such implementations must come from the state or from the local communities, not coercion by the state government. Under the current status quo, state and federal law dictate that if a school system is deemed in need of critical improvement, the state has the right to a takeover. Generally, this occurs of administrative problems, fiscal irresponsibility, unsuitable facilities, or poor academic performance. Unfortunately, Your Honors, such takeovers do not have the intended effect, but rather often hinder the educational process. And it is for this reason we stand resolved that the state of Connecticut should no longer be able to take over municipal school systems. We have defined a takeover to be when a state assumes control over an individual school or system and supplants some or all of the administration and faculty with state officials to whom governance is given for a particular period of time. This resolution must pass because of 3 contentions: suitability, efficacy, and integrity. Later on in this debate, my partner will explain the plan we have created for a successful adoption of this resolution. But now for our contentions. First, suitability. As reflections of a community, each school has a unique culture. And in order to be the most successful, education must be tailored to address the specificities of that culture and the needs of that student body. Educators close to a community are the best at providing this. State officials are not. They cannot provide adequate guidance because they are not privy to the social culture and sensitivities of any particular school. State takeovers merely add another bureaucratic layer to an already very complex process. There are many proven methods for improving the quality of a school, and state takeovers are not one of them. Our second contention is efficacy. State takeovers have been largely unsuccessful at improving academic performance. An expert from the National Center for Education Statistics Common Core of Data states that often such measures, quote, have yet to produce dramatic and consistent increases in student performance. This is because they focus primarily on management and fiscal issues, not education itself. In 2004, out of 58 takeovers, only 18 cited academics as reason for intervention. Your Honors, when the state assumes control over a school, removes the administration, and attends to only the fiscal and management problems, the attention towards and quality of education suffers. In the Detroit school system, after 5 years of state control, they saw a decrease in student performance. And after 4 years in a Newark school system, their funds went from a surplus to a deficit of more than $58 million. To an already struggling school, the duration, the cost, and the ineffectuality of a state takeover can be crippling, and they cannot be allowed to occur any longer. Our third and final contention today is integrity. State takeovers undermine the integrity of the individual, of the community, and of the democracy as a whole, because they give complete direction, autonomy, and control to unfamiliar state officials. These interventions enforce negative self-perceptions of students, administrators, teachers, and Board of Education members. And when their pride and their self-worth is damaged, their investment in the greater good of education is damaged as well. A school is the focus of pride and devotion for a community. But when its right to govern education is removed, the esteem held towards that institution is replaced with resentment and contempt. The role of a community in a child's life is diminished. And finally, in terms of democracy, education is a right of the people, and the right to govern our education is a right we hold as well. But when this autonomy is taken away, Your Honors, the virtue of a democratic society is undermined. Your Honors, the education of youth cannot be quantized and standardized as state takeovers make it. Rather, it must be tailored to fit the individual needs of each and every student. Choose to protect education and to ensure a brighter future. Choose suitability, efficacy, and integrity, and adopt this resolution. Thank you.
The first affirmative is questioned by the second negative. 2 minutes, Mr. Dubois.
Thank you. Ms. Petrovic, you are a student at the Valley Regional High School?
I am.
Okay. And the Valley Regional High School serves the students from Essex, Deep River, and Chester. And the Valley Regional High School has no problems with fiscal administration. They have plenty of money, don't they, to run their school?
Yes.
And their facilities are fine. They have no problem with broken windows or failing heat. And they have exceptional students and exceptional educational attainment, don't they? Okay. And you're a sophomore, you've got 2 years left, is that correct?
I do.
Okay. Now, assume that you were in a different school system, a system that had a failing infrastructure, a failing history of attempting to provide an appropriate educational environment. You wouldn't have the opportunity to wait around for a new Board of Education election to replace the leaders who have failed, would you?
I suppose not.
No. Would you agree with me that emergency circumstances require sometimes strong action?
I do, but I do not believe that strong action should be in the form of a state takeover.
Well, we disagree on that. You suggested in your affirmative presentation that there was something unique about the culture of the lower Connecticut River Valley that would require a specially tailored educational environment.
Right, I believe that a state official is not keen as to the differences in different communities.
But there's no college in Essex, Deep River, or Chester, is there?
No.
So when you leave the Valley Regional High School and move on to college, you'll be competing against students from other school districts and from other states for college positions?
Certainly.
Okay.
10 seconds, sir.
Thank you very much, ma'am.
The first negative constructive speech will be 5 minutes. Thank you, Your Honor.
Thank you. If it please the court, good morning. President Herbert Hoover said, and it has been oft repeated, that our children are our greatest natural resource. Very often we hear those words and we question whether or not our leadership is prepared to meet the needs of all children in all school districts and in all areas of this country. We oppose the resolution to avoid any interest in the state, by the state, in the facilities, administration, curriculum, or running of schools when they are failed schools. And we, in espousing the negative position, do not claim that this is a winner-take-all situation, because what we want to have happen is we want the children of the state of Connecticut to have equal opportunity to learn and to be prepared for the future. We really want people to grow into the citizens that a democracy needs and a democracy deserves. So we are singular as an exceptional, really, as a country and a state, that we have provided and need to provide and are required to provide a free public education for all children. It is not only our federal public policy to ensure equal opportunity in education, but also the policy of the state. In many respects, it is the responsibility of the state and not our local communities, who are agents of the state, to administer our educational programs, to provide that free, equal educational opportunity for our children, regardless of the location of their individual community. It is the state's responsibility to prepare our children for competition in a global world. This issue is a children's rights issue. It is not a voters' rights issue. It is not a home rule issue. And it does not have to be an issue where, and I believe that the suggestion in the legislation does not allow for a situation where the state can come in on any basis to take over that authority that it has delegated to a local community. What the statute that has been constructed does, rather, is that it focuses on failing educational institutions, institutions that have failed over a period of time before, and has also provided a measured and progressive discipline with respect to failing school systems, such that the state only in the last alternative, as an extreme measure, would come in and take over a school. In fact, in Connecticut, that has only been done once. And that was after 7 years of failing academic performance and an abdication by the board of its role. If our democracy is to thrive, it is critical that we ensure a suitable educational opportunity for our children. They are to be educated so that they fully participate in democratic institutions, that they are prepared to lead productive employment and contribute to lead productive employment lives and contribute to the state's economy, and also to progress to higher education. This has a fiscal component, and it is important to the state of Connecticut that its citizens be educated appropriately to become full, engaged, and contributing members of their societies. It's clear that constitutionally and by statute, it is the state's obligation to see to it that education is done. This is not a new idea to our constitutional history or to our jurisprudence. It is not a local issue. But the glaring disparity that we have seen in academic performance in our state, and an achievement gap between low-income and non-low-income students within our state, which is the worst in the nation. The state of Connecticut is obligated to respond to that, and it is in maintaining the status quo, in maintaining the statute that exists, that we do that.
May we have a moment of prep time?
Yes, certainly.
Thank you for your speech. In your constructive, you mentioned that it is the state's responsibility to ensure adequate education, correct?
Correct.
But do you really believe that it's the state's responsibility to take away a local community's responsibility?
I don't believe that it is the state's responsibility to take away a local community's delegation of authority from the state if they are performing, if the school is performing. And the state of Connecticut has in fact established and is required to establish uniform standards for all school systems. The state of Connecticut administers the Connecticut Mastery Test in grades 3 through 8, and the CAP test, the Connecticut Academic Performance Test in 10th grade, to measure whether or not students are performing. So the state has an obligation to not only uniformly test in the state of Connecticut, but report those measures so that schools have the information that they need to know whether or not they have to improve curriculum, whether or not they need to assess their teachers more appropriately, or whether or not the benchmarks should be altered in any respect. And the fact of the matter is that that is a requirement not only by state law, but by federal law in George Bush's No Child Left Behind Act. That is a situation where the federal government has stepped in because of the failures of some school systems. So while we would not argue that it is uniformly required that perhaps in school districts such as the school district that you attend, perhaps in other communities who have greater affluence, but in the low-income population schools, there is a danger that they will continue to... So I'll stop.
The second affirmative constructive speech will now begin. 5 minutes, please.
Good morning, Your Honors. My name is Katie Mulligan, and I will be speaking on behalf of the second affirmative in this debate. As my opponents have touched on, Connecticut has set a framework for the educational institutions in this state. It reads, Connecticut wishes to, quote, set and meet high expectations for academic achievement for all students in order to prepare them for productive adult life, continuing education, and responsible citizenship. However, Your Honors, the status quo is actively working against this statement. Instead of improving the academic achievement of students, allowing for state takeovers usually results in the opposite, pushing academics to the side. This cannot happen based on 3 solid contentions: suitability, efficacy, and integrity. We need to do everything in our power to ensure that our generation is equipped with the best tools and resources available so that we can lead successful lives. Allowing for school takeovers is an obstacle, and thus, we are here today to rectify this issue. My partner and I have devised a plan called the Effective Schooling Act for the successful adoption of this resolve. Our plan has been broken down into 3 concise steps. In the first step of our plan, Connecticut Statute Section 10, subsection 223E, allowing for state takeovers, will be repealed. As my partner has previously stated, the state is not suitable for taking over schools. School takeovers have proven to be ineffective, and they undermine the integrity of the individual, the community, and of democracy itself, and thus, they need to be banned. In the second step of our plan, we will require intervention plans. Under the Effective Schooling Act, each school will be required to create an intervention plan that they will then submit to the state. If a school fails to meet national and state education standards for 3 consecutive years, the state will require that that intervention plan be instituted. These intervention plans will allow for the state and the district to work collaboratively to address issues in a specific school system, and thus holding each school responsible for for improving performance. In the third, these intervention plans may include, but are not limited to, A, intensive academic programs. This is where structured curriculum is used in conjunction with measurable goals and targeted staff development. B, improvement planning. This is where the school system must outline strategies they will use to bolster achievement in terms of financial success, management, and academics. C, technical assistance. This is when the district can request for teams of experts and curriculum specialists to visit the school in a setting such that they can offer advice and recommendations on how to improve. And finally, D, additional resources. School systems will be able to apply for additional money from the state for specific purposes and programs that they feel will better student achievement as well as the facilities. And in the third and final step of our plan, we will have mandatory conferences every 3 months. Every 3 months, there will be a conference with one representative from each school district held at a central and convenient location. Each conference will have a different topic. Experts will come in and give seminars on topics including fiscal planning, management strategies, how to improve test scores, etc. The conference will be funded by the state. The goal of the conference is to have the representative then go back to the school district, share the information on a smaller scale, and then utilize that information when it's needed. This will again facilitate a collaborative approach between the state and the school districts. And in the most extreme cases, when the intervention plan does not show improvement within 2 years, we would allow for mayoral takeovers, due to the fact that mayors tend to be more in touch with the community efforts and the needs of the community. In the past, mayoral takeovers have proven to be more successful in their results. Your Honors, this plan is the only option if we wish to uphold the integrity of our education system and of the democratic processes that define America. We need to put these measures into effect immediately in order to enhance the education of students statewide. They are the future of our country. Therefore, Your Honor, I implore you to choose suitability, efficacy, and integrity and adopt this resolution. Thank you.
Just need 1 minute.
Yes, Your Honor. The second affirmative is questioned by the first negative. This will be 2 minutes. Let me know when you're ready for me to start timing, Your Honor.
I'm all set.
Okay, thank you.
Would you agree with me that the statute currently in effect requires an operations audit to identify possible programmatic savings and an instructional audit to identify any deficits in curriculum and instruction or in the learning environment of a school or district?
Can you reword that for a layperson, please?
I'm sorry. In terms of the progressive discipline that occurs in a failing school, would you agree that the current statute as it stands requires certain steps, and one of those steps is an operations audit and an instructional audit to identify any failures in a school?
Sure.
Okay. Would you also agree that the statute now requires a local or regional board of education to use state and federal funds for critical needs?
Yes.
All right. And would you also agree that the current statute requires that the school provide incentives to attract highly qualified teachers and principals?
Of course.
Okay. And would you also agree that the state statute would require the transfer and assignment of teachers and principals in a process of improving a school?
Yes.
And would you also agree that the current statute requires additional training and technical assistance for parents and guardians of children attending failing schools, and that, withdrawn, that the statute as is currently constituted directs additional training and technical assistance for parents and guardians of children attending the school.
Okay.
And would you agree that that is consistent with the statutory directive that the community become and remain involved in the workings of each school community?
Well, we're
Time. We now will proceed to the second negative constructive speech for 5 minutes, please.
If it please the judges, special circumstances require special responses. The half-life of a generation is only 12 years, and not coincidentally, that is the full extent of the period of free public education that our society provides. And children in a failing school system do not have the luxury of waiting for another election or hoping a new Board of Education will get it right, or that the problems that are plaguing their school system and their educational experience will be corrected in enough time so that they can reap or enjoy the benefit. The correction of a troubled school district or school system or school exists at the intersection of politics, policy, and poverty. Politics because we cannot escape the fact that schools and governmental functions exist in a political environment, and therefore it is important, as my opponents have suggested, that we have local buy-in and local agreement. Nevertheless, when the political system fails, we would submit that it is too important that we not ignore the problem for the sake of not hurting the feelings of people who might feel temporarily dispossessed from the political environment. The second point on which the problem must be solved has to do with policy. And again, policy is important because the operation of an effective school system is not something that we can intuit. It's not something that comes naturally to us. It is something that requires careful crafting by educational experts. And I would submit that while local communities may have broad access to talent, on occasion they may find themselves needing expert assistance. In cases of abject failure, it may be that the assistance has to be forced as opposed to requested. The third point where all of this meets is poverty. And poverty exists in these failing school systems in two instances. The community that is being served is often extremely poor, and children in these environments have many cards stacked against them in the educational deck. It's impossible for the educational system to undo in 8 hours what life in their community has done to them in 16. But also, there's a problem in failing school systems of institutional poverty. And that is that often these failing systems simply don't have the money to provide appropriate and safe and efficacious enterprises. They require external sources of funding. The problem is that external funders, both private and governmental, will not invest in failure. The present system that we have in responding to failure is reasonable, measured, and time-limited. It is intended and designed to approach quickly, efficaciously, and in a short period of time, responsively to educational failures, so that students who find themselves trapped in failing school systems can be rescued, because there's nothing worse than writing off a generation of students while the adults who have been charged with making their education appropriate try to get it right. Our law has often and historically recognized that exigent or emergent circumstances allow for suspension of what have been traditionally understood as local or personal rights, including the right to be on a Board of Education or vote for a Board of Education member. We would submit that the present system works. It is an appropriate remedy for a dangerous and problematic circumstance which occasionally occurs and will occasionally be needed to be invoked.
Time.
Can we have a minute of prep time, please?
Yes, correct.
The second negative is questioned by the second affirmative. This will be for 2 minutes.
So you claim that the current system works, correct?
The current system exists as an available remedy. It's only been tried once, and it wasn't given the opportunity to work.
So in that one instance, did this state takeover, did it go over well?
It was not acceptable to some members of the community who did challenge it.
Okay, thank you. And you say that institutional poverty requires external sources of funding, correct?
That is one solution, yes.
And are you aware that our plan provides them with the funds to rescue the student?
I'm not criticizing your plan. I just think that we don't have time to substitute a new plan for one that's already in place and can be invoked in cases of emergency. Your plan has many, I think, appropriate and well-considered points, many of which are contained in the existing regime.
And you say that takeovers are applied efficaciously, correct?
Well, there's no prescription for success, but I can tell you the prescription for disaster is to do nothing. And hope things will get better.
And do you have any figures on the effectiveness of state takeovers?
Well, the whole concept of state takeovers is fairly new, and I'm not aware of any empirical studies that have done. I think it's still a work in progress.
And what makes the state that the go-to expert assistant that needs to come in when there's a failing school system?
Historically, education has been considered to be a state function, and therefore I think that the state is the appropriate last resource and last remedy when the local individuals and the local system and the local citizens can't get it right.
So you do agree that currently it is the local responsibility to run education?
It's not a matter of right, it's a matter of privilege. The state has allowed local communities to run their educational system.
We'll now proceed to the second negative, the first negative rebuttal, which will be 3 minutes, please.
It is very clear in the course of this debate that we have agreed on fundamental tenets, and that is that there is a universal desire to provide an equal educational opportunity for all children in the state of Connecticut, that there be state action with respect to how academic performance is measured, how it is reported, and how we are as a community at large, that is as a state community, how we should tackle the issues of trying to save failing schools. So I suggest that it is, with respect to suitability, that the statute that is in place reflects the goals of our community, that those goals are to prepare students for the 21st century, to prepare them for a global economy, and to make students involved and engaged citizens in the state, whether it be on educational issues, political issues, or on any issues that creates their passion. Education is there to put the passion in place. The system that is currently in place in the state of Connecticut has efficacy. It is, in fact, successful in bringing up not the scores of every school, but in many schools. And I believe that the process in place to not only assess teachers, but assess curriculum, to give information to support the locally delegated authorities who run either regional schools pursuant to statute or local schools is something that is already collaborative. There is no us versus them mentality. And certainly the fact that the state has the obligation to educate its children and ultimately the power of the state to do that, the power of the state to delegate its authority to local or regional boards of education, does not undermine the educational process. It is important that the state be involved. It is important for a variety of reasons. We cannot have a school which has a dropout rate that is 4 times larger than the mean in the state of Connecticut. We cannot accept a school system that has failed for 8 years. And we cannot afford the billions of dollars in lifetime earnings that will not be earned by those people who drop out of high school. We cannot afford what are the consequences of a lack of education, including crime. And we cannot afford to have people not engaged and productively raising their families.
Stop. Thank you. We'll now go to the first affirmative rebuttal, for which there will be an additional 3 minutes. Are you ready?
Yes.
Okay.
Hello again. I would like first to begin by addressing my opponent's, or boiling down this debate into what it really means, then addressing my opponent's claims and finishing off with my own. Now, ultimately, this debate is, as my opponent so eloquently stated, a debate about education and children's rights. We both agree that each and every student in the United States is entitled to equal, successful education. The way this is delivered, however, we tend to disagree on. While my opponents are proponents of the status quo, where states are allowed to swoop in and really take out the administration and supplant their own state officials, they support this. Whereas today, we the affirmative have proven to you that such interventions cannot be allowed any longer. We have shown that they are unsuitable as the tool for which the job that is required. They are ineffective because they've only been used in the state of Connecticut, as my opponents have stated, one time. This is in Bridgeport. And this later on was repealed was deemed unconstitutional by the state court. So the one time that we have tried this takeover, it has been repealed and shown unconstitutional and ineffective. So we believe that stands on its own. And our third point is that it undermines the integrity of the community, the individual, and the democracy at large. Now, my opponents have spun this point to turn it to that this issue of failing schools is far too important to ignore the problem in hopes of not to hurt a couple of feelings. Really, that's not what we're saying at all. With the plan that we have proposed, these matters, these problems would be addressed immediately, right away, just as the state would do. However, the way in which we are doing that is much more effective, much less drastic, and then overall much more successful. So now, again, my opponents have claimed that time is of the essence, and we cannot wait around for another election for the Board of Education. However, state takeovers, though immediate, are more damaging to a school system, as we have shown. And though my opponents have argued that the state historically has the power to delegate, we have shown again that extreme cases of takeovers have failed. They have not been successful. So regardless of whether it is the state's right historically to delegate education, if it doesn't work, it shouldn't be allowed to happen. Simple as that. And in terms of politics, my opponents have asserted that it is too important to ignore the problems for the sake of hurting a few feelings. However, as we have said, we are attending to the problems. We are doing it in a much more effective way. Now, Your Honors, I'm a student, my partner is a student, we all have been students here, and we know how important education is to our society. But if we allow a state government to swoop in and remove the administrators and the faculty and everyone from a school system, from that community, and to attend to the managerial problems, then education is not being rectified. Rather, we're just adding a Band-Aid onto it. Thank you, Your Honors.
Second negative rebuttal for 3 minutes.
If it please the panel, my learned opponent, I think, misspoke. Our Supreme Court has not found the existing system to be unconstitutional. The case that was at our Supreme Court was resolved on procedural mistakes and not constitutional issues. There is no constitutional right to serve on a local board of education nor to vote for a member of a local board of education. But even if there was, we have a proud tradition in the United States of recognizing that individual rights may be suspended for the common good. President Lincoln actually suspended the right of habeas corpus during the Civil War when he felt that it was important to suspend very important individual and constitutional rights to protect the viability of the United States as an entity. And we would argue that education is equally as important. Education is not an area where you get points for trying, where boards of ed get a lot of hugs and well, you didn't get it right this year, but come back next year and maybe you'll get it right. The only appropriate metric, the only appropriate standard to measure boards of education is success. And if an educational system, whether it be an individual school or an entire school district, has a failure, a history of failure, it is appropriate for the state to come in and dislocate the troubling and problematical parts of the local system and to take corrective measures. There's nothing that will prevent the community from buying into the state substitution. Actually, we would submit that parents will embrace and welcome success because they, as we, have only the best interests of their children and will not sacrifice those interests for the political concerns of those who believe that they know better and should be allowed to continue to run a failing system. Thank you.
May we take our remaining prep time, please?
Yes, of course.
You have a minute left to your aggregate time. Now proceed with the second affirmative rebuttal for 3 minutes.
Your Honors, today the affirmative has shown the harms of keeping the status quo. We have proven through facts and figures that the state is not suitable to run a local school system due to the fact that they are not in touch with community needs. Our opponents point to history as the reason to show that states are the go-to person for fixing a school system. However, in the past, state takeovers have shown to fail. Even in Bridgeport, the state takeover failed. We need to change the course of history, and we need to no longer allow state takeovers to occur because they are hurting our education system. We believe it is important for the state to be involved, as our opponents have stated. But we wish that this does not come in the form of completely taking over a school system, but rather working collaboratively with the district to make a school better, so that when the state leaves, the district will be able to function on its own and know how to run a great school system on its own without the help of the state. Our opponent has not given any reason to show that adopting this resolution would fail. Again, they cite history as a reason not to change. Our plan would adopt this resolution, strike school takeovers, which again have had a history of failure, and then add intervention plans, which will provide for better education without undermining the integrity of the individual, of the community, and of democracy itself. Your Honor, have you ever heard this quote, "It takes a village"? We do not submit that failing schools do not get help, but rather that this help is delivered in a more effective, less damaging way, as evidenced in our plan. We want the state and school districts to work collaboratively. We do not want the school to come in and completely take over a school system. Your Honor, it takes a village to raise a child, not a state. Thank you.
Ian?
That concludes the remarks, Chairman. The judges will now take a few minutes, as I understand it, to
Yes, but
confirm.
before we do, I'd just like, I remember when Attorney Monaco was making his remarks, that he was adding up years of service of lawyers. So I've added up the years that the three of us have been lawyers, and it comes out to something above 90. But the years that we have been debate judges comes out to something below 0. Almost too high of a standard.
As nice.
Court is in recess momentarily.
Nice
Nice
job.
job.
I loved your last line. It was a great finish.
Thank you. Great job.
Of course, I have this notion that it was over two girls arguing because, you know, I came up it was a struggle.
Yeah.
You know, the guys are going for it. I keep myself in it.
Thank you. Thanks very much.
That's right, yes. I have so many ideas already.
I know.
As you go through, it always happens.
Yeah, your best arguments are the ones you think of on the way home.
That's right, always.
Oh, thank you so much. Oh, do you want it? You can have it.
I have some more.
Thank you so much.
They're terrific. They're really
They're great. We were just commenting on how cool they were to say.
Your Honor, if you would read the decision of the judges, that would be much appreciated. And if you're available for any comments or questions from the participants, that would also be appreciated.
Each of us may make some comments. I will. This was really interesting. Everybody was terrific. One of the, I left my comment sheet in the other things, so I have to make this up as I go along. But one of the things that I noticed was that the affirmative team, Phoebe and Katie, were really well organized, and they knew how to keep their points going and how to repeat them and summarize them. And the other thing I noticed was that Phoebe's use of language was really very interesting, very strong. Scoop down and take over the schools, I thought was particularly good. But there were several examples like that. And so those are. I don't think I'm going to make observations about the other two.
better not. Judges, could you speak into the microphone? It's a little hard to hear.
We tell them. Oh, well, I'll just very, very briefly, I mean, I don't want to leave you sitting, without knowing the big result, but my overall observation is that we were handed really remarkably lengthy sort of instructions about how this whole debate is supposed to go. And there is a structure to it that people in the audience might not appreciate without knowing these. I mean, really, it's like 6 or 7 single-spaced pages. We felt that part of the discipline here was adhering to the format which is established for this proceeding, and the organization and what you're supposed to do. My overall thought was that Phoebe and Katie showed they are real veterans of this particular discipline and backing up
their points and doing the order of what you're supposed to do. And in rebuttal, you have to mention your points, or else they are deemed waived or forgotten. And it was very interesting to view it in that way. I thought that Judge Youngrenis and Mark Dubois showed, particularly on cross-examination, that they're very accomplished attorneys. That's where the skill and experience and all that it kicks in naturally after a combined 135 years of experience. I'm not going to say how that 135 is divided up. It doesn't my overall. I mean, obviously everybody was just terrific, but it struck me that there is a specific discipline here that is being dealt with.
I just had very brief comments, but we don't want to keep you waiting. And if our presiding judge would announce the winner, then I had just a very brief comment to make. Would you announce the winner?
Yes, I will. But and after you make your very brief comment, I will have a very brief comment.
And I won't. That's my brief comment.
The winners, but by and the three judges, we each scored this individually, and the patterns of how we scored it were pretty consistent among all three of us. And the winners are the Valley Regional High School, Katie and Phoebe.
Thank you, Your Honor. I just had two very brief comments, I guess, on it. You guys are extraordinary. You should be extremely proud. Your school should be extremely proud for it. I found myself thinking, and Judge Youngrenis and Attorney Dubois are also extraordinary. And they have combined 190 years of experience in what you guys have, and especially at the stage that you are. Just congratulations to both of you. But what I found myself thinking, maybe apropos of Law Day, I actually think you guys have the tougher argument to make on this one in terms of my own view of the merits. I found myself thinking it would have been very interesting if it were switched the other way, because I would have been interested to hear what kind of arguments you would have developed on that side, because I think Judge Youngrenis and Attorney Dubois came up with very, very powerful arguments for what I view to be probably the winning side in this. But back to the Law Day piece of it, I teach trial practice, or I did before I became a dean. And one of the things that I tell my law students is that the easiest way to be persuasive is to be right. And that it's a good trial lawyer, a good litigator, can come up with strong and powerful arguments, even for a losing side, and that's sometimes what we're required to do as attorneys. But I was a litigator, and I always felt it was my responsibility to serve my clients, to let them know if I thought that they didn't have the better side of the case, and that was the kind of case we should try and settle. And it was a case that I should try and work with them to educate them. I was an employment lawyer, to figure out how they would avoid making mistakes that, again, could get them in a bad situation. And that, so I found myself thinking, all of us felt that you guys really showed your experience and the great training you've gotten from your school and the great practice you've had as debaters. And for the format and the requirements of this particular task, did the better job on it. But I did find myself thinking it's easier to be persuasive when you're right about things, and that's a lesson for lawyering, I think, sometimes too. But if you guys are thinking about law school, give me a call. I'd love to talk to you, and congratulations, and you guys, fantastic job too. Very, very nicely done.
All of them should give you a call?
Yeah, I'm breaking my word here. I will say just one quick thing about Law Day, because that's what this is most of you are probably aware of the Founding Fathers' notion. Of course, there was discussions if democracy would work. Would a constitution work? And James Madison read every written constitution ever produced before essentially writing our Constitution. One thing they all agreed on is that democracy cannot work effectively if you don't have civic virtue. And civic virtue meaning putting the goals of the nation above any particular situation of your own. In other words, you seek the common good as opposed to your own good or your family's good. And part of civic virtue is the sort of debate we saw here, where people were discussing principle in a rational manner. It wasn't whose bread is buttered. It wasn't who gets, the money. It was really rational civil discourse over a current problem. And I think that it is the essence of Law Day. And I just wish that politicians everywhere could act as honorably and nobly as you did today.
Judge Dren-Guinness asked me to sum up, but I can't do it better than Judge Beach did, so I'm going to not. Thank you. Thank you all for coming.
Now you can go back and brag.
Thank you very much.
Thank you.